morning. Okay, it's closer. Thank you for joining us this morning for the Oregon State Board of Agriculture meeting. Today is Thursday, November 17, 2022. This is Luisa Santamaria, Chair of the Board. This meeting is now called to order. I would like to begin by asking the Department of Agriculture Board Coordinator, Carla Balnes, to review a few housekeeping items for the meeting.
Good morning, everyone. Just a reminder to please keep your phones and computer audio on mute to avoid any unnecessary background noise. If you're joining on video or on the call this morning, our pre-materials are available on the ODA website under oda.direct/board agriculture. And just a reminder that we would like participants to keep their web camera off unless they're giving a presentation or are a board member. And just a reminder that today's meeting is being recorded.
Thank you, Carla. Carla, will you please call the roll for introductions? But I think I will begin. I'm Luisa Santamaria, a public member, extension at Oregon State University.
Chad Allen.
Chad Allen, farmer in Tillamook.
Barbara Boyer is excused today. Brian Harper.
Brian Harper, member and farmer in Junction City.
Shante Johnson.
Good morning, Shante Johnson, board member, Corbett, farmer in Corbett.
Miguel Lopez.
Miguel Lopez, public member, farmer in the Willamette Valley.
Elin Miller.
Elin Miller, farmer in Umpqua, hazelnuts and wine grapes.
Eric Oram.
Eric Oram, farmer, wheat and cattle, Heppner, Oregon.
Randy Savati.
Randy Savati, farmer, Ontario.
Josh Zielinski.
Josh Zielinski, farmer, Salem, Oregon.
Dean Simonich.
Stacy Simonich, Dean of the College of Agricultural Sciences at Oregon State University and Director of the Oregon Agricultural Experiment Station.
Acting Director Henderson.
Lauren Henderson, Acting Director, Oregon Department of Agriculture. Good morning.
We'll do a quick around the room. Chris, do you want to start?
Chris Benman, Oregon Department of Agriculture.
Jonathan Santos, Assistant Director, Oregon Department of Agriculture.
Susanna Perlstein, Program Manager in Market Access and Certification.
Hi, I'm Dave Losh. I work as the State Statistician for USDA National Ag Stat Service, based out of Portland.
And I'm Jim Johnson, Land Use and Water Client Coordinator for the Department of Agriculture.
Thank you, Carla. We will have a public comment scheduled for today at 9:45 a.m. If there is someone that would like to sign in for the morning to provide verbal comments in person, please use the sign up sheet on the table prior to the comment period. I don't know, we have somebody joining the meeting online. If there is a request, please use the chat box, including your name and organization. Okay, just a reminder that this is going to be recorded, and please state your name for the record before you begin your comments. And so we will start with the first item in our agenda, that is ODA Produce Safety Program Outreach and Discussion. Please, we have Susanna Perlstein.
Hi, everybody. I'm Susanna Perlstein. I'm here with Casey Prentice. Casey is on remotely. Carla, we're ready for whenever you are with the slides. But I'm here today to talk about, again, the Produce Safety Rule program in Oregon and how we're implementing it at Oregon Department of Agriculture. And so just for background, this program became a program when the Food and Drug Administration offered states back in 2015 funding to take on the implementation of the Produce Safety Rule, which is part of the Food Safety Modernization Act. And so this program has multiple rules established in FSMA, or the Food Safety Modernization Act. And the produce safety rule is one of many that basically is establishing science-based minimum standards at several aspects along the food chain. The produce safety rule specifically deals with the produce we eat raw. And so our program, Carly, you can move on to the next slide. Again, we're fully funded by a grant from the Food and Drug Administration. And what we do here is we decided to take on a non-regulatory program. So that means we're focusing on technical assistance, outreach and education, and compiling a farm inventory. So a listing basically of farms that are subject to the produce safety rule. Because that's important because farms that are subject to this rule, they don't have any opting out of this federal regulation. It's very similar to, but it's very different from a third-party food safety audit where, for instance, it's usually dictated by the buyer. The buyer is saying, hey, if you want to sell to me like a Walmart or a Winco or whatever, you have to do a third-party food safety audit. And so to some extent, that's a voluntary thing, right? In terms of the buyer saying this, if I wanted to, I could find another buyer. That's easier said than done, right? But the produce safety rule for farms that are subject to it, it's capturing most farms that are growing produce depending on their income. And so it's not just the farms that are doing these third-party food safety audits. So you have a lot more farms that have to follow things related to cleaning and sanitizing of equipment, worker health and hygiene, agricultural water. There are a lot of different aspects. And so we have a non-regulatory program, so we're helping to implement the rule in that way, mostly through technical assistance. So that means that the Food and Drug Administration is doing the actual inspections on the produce safety rule in Oregon. So for our program itself, we have a partnership, a sub-award with Oregon State University, and we have 4 people in our current program at ODA. We're hiring the 4th person right now, and our operating budget is $630,000 a year. Next slide, Carla. So with our partnership with Oregon State, we're able to provide them some sub-award funding to basically help us increase our reach around the state. So we have Dr. Luisa Santamaria, who's based at the North Willamette Research and Extension Farm, which we toured yesterday. She's a plant pathologist. And then we also have Dr. Stuart Wrights with OSU over at the Malheur Experiment Farm. He's the director there. He's also the director of the Experiment Farm in Hood River. Then we have Dr. Jovana Kovacic. She's a Listeria expert. And then we also have Dr. Joy Wade Cusick, who's based at the main campus in Corvallis, and she's a microbiologist. And then our staff currently are based all in Salem. And next slide, Carla. And so what we're doing there together with OSU, with our program, is 3 main things. So I talked about, outreach and education. So there's one class that is recognized by the Food and Drug Administration at this time that is a requirement for farms that are subject to the rule to have attended this class. And so we've trained well over 1,000 people so far in Oregon, and there are more to go. So that's a big part of it. We also do a lot of technical assistance where we're able to go on farms if they want us, it's totally voluntary, to basically assess, hey, this part of your operation is really strongly aligned with the rule, and this is where you could improve a little bit. So it's not a pre-inspection, it's not a consultation visit, it's just an assistance visit. Like where you come out, we look at the farm through the lens of the produce safety rule. And so it's free, it's voluntary, and right now it's confident, or not right now, it is confidential. So if we take any notes, it all stays with the farm. And then the last biggest part of our job is keeping this farm inventory, because again, farms that are subject to the regulation, there's no opting out. And so it is our job as part of our agreement with FDA to identify which farms are in Oregon that are subject to the rule so that they know what they might have to do to be in compliance. And also we have to provide that list to FDA periodically so that they know which farms might need to be inspected. So next slide. So let's talk a little bit about why we decided to not do inspections in the first part, because a lot of these 3 items really ring true still today. Funding is a big one. So when states were approached back in 2015, it was a 5-year program to implement this very new broad federal regulation. So right now we're in year 7. So we're in our second kind of funding cycle, and that'll be for the next 10 years through 2020, or 5 years. It'll be 10 years total since it was implemented, so through 2026. So at the time, the question was, okay, there's limited funding that's being offered to states. If we implement this full bore, what happens? Where does the financial burden fall if the program goes away? So funding was an issue. then the other thing was industry. At the time, partly because of the funding part of it, industry was not in favor of us taking on that regulatory program. And then the other part of it, which still also rings true today, is that multiple parts of the rule, soon after it came out, were put on hold. So that means things like our agricultural water portion of the rule and the farm definition, kind of the basic principle of the rule, are still on hold and not being regulated against. So when FDA is out there, they may talk with you about something like the agricultural water portion of the rule, but they're not regulating on it. And those are still true today. So we do still have funding issues in terms of funding has been reduced in this second cycle that we're in. Again, we're in year 7. So we're a little bit reduced, and we'll talk about that in a moment. Our industry is what I'm going to focus on mostly today in terms of where they're at. And then the rule is still not finalized in several aspects. So we have a proposed new agricultural water portion of the rule, but it hasn't been finalized yet. Next slide, Carla. So today, we've been talking with industry, I'd say, every day since the program started. We've just chatting with farmers. A lot of that's done through cold callings and chatting individually. And it's a little invasive to call somebody up out of the blue and say, hey, have you heard about the federal regulation you might be subject to? But we wanted to, so throughout the program, we've been kind of taking the pulse. Where is industry at? How are we doing? How are they feeling about how the regulation is being implemented in Oregon? But recently we wanted to kind of revisit this aspect of what does the industry actually want ODA to do? Do they want us to stay as we are in non-regulatory? Do they want us to move forward? So we've done 4 main listening sessions just this year around the state. So we had one in Aurora, we had one over in Ontario, one in Hood River, and then one down in Ashland. And we've couched these with some other commodity-specific outreach issues. So in Aurora, we talked a lot about the cleaning and sanitizing of these mechanical harvesters, as well as like our buckets, our hand-picking buckets. We talked about the bins in Hood River, which is a difficult issue because these bins are frequently bins the farmers don't own. They just get back, and they're in various stages of cleanliness. So there's a lot of issues that we've focused on. And then we've couched kind of at the end of these listening sessions, just a general discussion of how are things going with you, the farmers, in terms of folks who've been inspected, how's the burden on what is the burden on FDA from them, as well as what are they hoping for us to do? Like, do they want us to stay as is or move on to regulation? And I'd say those conversations pretty much always start out with the farms being interested in us taking on a regulatory approach because they're interested in Oregonians who work in Oregon agriculture being the ones who are inspecting it, right? But then as the conversation develops and we talk about what that would actually look like in terms of if funding goes away, the fact that we would actually be acting under FDA authority, so the inspections wouldn't actually look different than they do today, and the amount of burden that we would be physically out there. So, and next slide, look, Carla. So as we start out with these listening sessions, there is this inclination to go to a regulatory program. But then when we get into the actual details of what it is, there is a lot of hesitancy still from our industry across the state. This is just a really brief timeline of where we're at. So the gray box on the far left is just our last 5-year cycle. And now we're in our 7th year, so the second 5-year cycle. And so if we were to go on to a regulatory program, we would need to apply by March of next year. Next slide, please. So if we did that, so just for an example, our current operating budget per year is $630,000. Now, that is $100,000 less than we had in our previous 5-year cycle. So that funding, and not just for Oregon, but across the nation for states that are implementing this regulation, has been reduced by FDA. If we were to move into a regulatory program, we would get an additional $500,000 to implement that work. Next slide, Carla. And it's not just if we did that, we wouldn't have to do any of the other work. No more outreach and education, no more that. We'd have to do that in addition to the inspection program. So that's fine, but let's take a look at what that looks like. So FDA requires all states, everybody who's as a regulatory program, to inspect 20% of the farms that are in their farm inventory that are subject to the rule every single year. For us today, where our farm inventory is at, and by the way, those numbers keep growing as we find new farms, new businesses get established, we'd be having to do 165 inspections every year. And so for that, we would have to hire at least 3 inspectors. And that would, so they'd have about 55 inspections every year. And when you think about that, it's not just necessarily spread out over the whole year. We've got a seasonality of farming. We've got a bunch of other prep to do in that sense. So that's what the work burden would look like. That's part of the staff load that we would be adding to the program with that funding. Next slide, please. And so it's not just the inspectors that we would be adding. We would also want to be adding an administrative person. And while we're hiring right now an outreach coordinator and NRS2, we'd also be utilizing them quite a lot in helping with the inspection planning and analysis side of things. And so what's in blue on the left-hand side is our current budget. And so right now our current salary percentage based on the whole of what we're getting for funding. So we're at just over 64% for our salary in terms of the whole amount of funding. But if we move to regulatory program, what we anticipate and what is also mimics other state programs that have a regulatory program is our salary percentage would go up to about 74% of the total budget, just based on the amount of work that we have to do and how we're analyzing how we'd be able to accomplish it. So that doesn't include anything like travel or building rent or subaward with OSU or the materials and costs that we have just to kind of exist and get our program moving forward. Next slide, Carla. So what we're thinking and what I'm presenting is that the amount of money that we would have added if we added a regulatory program, it would bring us up to $1.1 million, just a little bit over. But in terms of the amount of staff and the burden of work that we would have to be doing, and with the reduction that we've been seeing over the cycles with FDA, we're not sure that we would have enough program funding to continue providing enough support to the state for all of the other aspects, as well as meeting our goals that we would be absolutely required to meet by FDA in terms of inspecting that 20% of our farm inventory. And so this is just, again, the same slide that I showed before in terms of the amount of inspections we'd have per year as of right now. That'll probably go up a little bit as we're still verifying our farm inventory. And so that's really, the last slide is just thank you, and that's my summary. But I'm here to answer any questions if you have any. And Casey, if you have anything to add.
Elin Miller for the record. So help me again on the delta for the dollars, and how have other states that did go this route supplement? I think I know the answer, but I don't know for sure.
Yeah, so it really depends on the state. So, and there are a few things in terms of some states just they don't have as many farms that are subject to the rule as we do in Oregon. But some states have been able to utilize their staff for the program in other program areas. So they'll split their time doing inspections in other areas or working in another program during the off season when they're not doing that. Some folks have really, really reduced their outreach side of things and brought it down to one staff member, or it's really would have to be one staff member. There is a great conflict of interest if you have somebody. We can't have somebody going out to do a technical assistance visit and then the next week coming out and inspecting. That's just not going to happen. Or build trust, let's be honest. So that's how a lot of states have done it. There's been a reduction.
If I could, Lauren Henderson, at the last NASDA meeting in Saratoga, New York that Jonathan and I attended, this subject came up. And it was an opportunity, I think, for the states to express concerns to FDA about where we're at today. I couldn't help myself along with my colleague from Idaho, but we laid it out in pretty black and white terms that when former Director Koba was head of the Food Safety Committee for NASDA, this issue of this delta was brought up, and here we are still with it, and it hasn't been solved. And the states that jumped in did so, but now they're also struggling with how do we make this delta up with budgets the way they are. It was a hard conversation, I'll just say that, but it needed to happen as a reminder. We got a commitment, I think, from NASDA as well as FDA to really figure out what working together looks like in this space, because FDA needs the states to do this. They don't have the capacity to take on this. Congress gave the act to them to implement. And so I actually felt pretty good that it got put on the table again as a conversation piece, and I would guess in February we'll hear more about it. There were some commitments made and some changes made that I heard that I didn't actually think I would hear there. So it didn't solve the issue. We're probably going to have Susanna keep coming back here until we can figure out what we're doing, because we're at that crossroad, I think. But we'll see, more to come on that. But I had told them I was disappointed that we were still talking about this 10 years later or however long it's been and it hadn't been solved, and that they were expecting the states to just eat the delta, and that's just not possible. And now that being said, FDA doesn't have control over Congress and how they allocate. So I would expect there will be a robust conversation coming up soon about that and how they fix it.
Eli Miller, just a follow-on question. Thank you for that. But the drop dead is March 2023. So are we seeing any potential resolution to get in that loop, or can you jump in later if somehow this got fixed, if we want it?
So from my conversations with FDA right now, based on the funding cycle and that March 2023 kind of deadline to apply for the regulatory program comes from a few different aspects of, there'd be about a year of overlap where if we applied, it wouldn't be like we'd start doing the inspections the next day. There'd be a transfer of data, there'd be a hiring of folks, there'd be a development of the program, training those folks to get going so that we're actually implementing it properly. And if you think about it that way, our funding cycle goes through 2026, right? And so that really wouldn't leave us with a lot of time if we applied in 2025, for example, or 2024. And so we are anticipating, I don't know what will happen in the future. We're anticipating there will be another 5-year funding cycle. We are anticipating that there will still be the opportunity to apply for regulatory funding. That's what we hear from FDA. So in this funding cycle, that's the deadline that they've provided to us. I don't think that's the last one we'll have.
Luisa Santamaria, is there a chance to apply only for outreach and education?
Yes, that's what we have currently.
You're going to continue doing that?
That's what we're here to talk about a little bit in terms of we have been doing that, and so that we just have the regulatory program. And so as of right now in our 2 cycles, FDA has offered that option to just have, right now we're called a Path A state, right? Mm-hmm. In terms of just the outreach, just the education. So yes.
Okay. I think there are no more questions. Thank you, Susanna.
Thank you so much.
All right, so let's continue with our next item in our agenda. We have now the right to farm overview, and the presenter will be Jim Johnson from ODA, Land Use and Water Planning Coordinator.
Stand up here so you don't have to go ping-pong back and forth.
Sure, whatever you want.
They can't. You need to be over there because the
Okay,
folks on
no,
the
it's
line
not
can't
whatever
see
you want.
Oh, no, it's fine. It's just like they'll go back and forth because the slides will. Whenever you're ready, Carla. Good morning, everyone. For the record, Jim Johnson, Land Use and Water Planning Coordinator for Oregon Department of Agriculture. What we're going to do for you today is kind of give you a primer on Oregon's right to farm statutes. This is something that I deal with quite a bit, especially seasonally, during harvest time especially. And it's something that's very misunderstood, I believe, by the ag community. So I think it's probably time we go through this. I haven't given this presentation to the board for, I don't know, 10 years. So it's, none of you have probably seen this. So with that, we'll get going with it. Next slide, Carla. So Oregon's right to farm statute is just that. It's a statute. It's not a regulatory statute at all, and it's really it's been around now, I would say, for, I can't even remember, probably 20 years now or something of the effect, and it's been amended twice. Right to farm deals with nuisance and trespass related issues stemming from agricultural practices and for forest practices. Actually, also the statute is right to farm and forest. Of course, we focus on the farm side of things, and historically, I have not heard of too many cases on the forest side that Department of Forestry might have related to, whatever. But nuisances are things such as listed here: odors, noise, dust, that type of thing. Next slide, Carla. And then there's other conflicts that are not right to farm related. They're not nuisance or trespass. So those would be things like control of animals from properties, theft and vandalism, traffic, chemical uses, host for pests, these kind of things that impact your ability to farm. These really aren't nuisance or trespass cases. These are much more compatibility or land use cases, and that's a whole nother presentation we can do sometime in land use in terms of how the land use program works there. Next slide, please. Oregon's right to farm statute is found in ORS 30.923. It has two major components. One component provides immunity from private legal action to a farmer. The second component of it prohibits local governments from regulating farming practices for nuisance or trespass reasons. Next slide. But right to farm is not a blank check. This is one of the fallacies that I get a lot of times. People will basically say, I can do whatever I want to because I'm protected by right to farm. It doesn't work that way, and so let's talk about that. Oregon's right to farm has qualifications. You have to meet certain standards to actually then qualify to be protected by right to farm. This is right out of the statute: no farming or forest practice. So that's the first component. Is it a farming or forest practice? And we're going to talk about what that is in a minute. On lands zoned for farm or forest use, so it's got to be zoned. So there's a land use connection in the statute. So lands zoned for farm or forest use shall give rise to any private right of action or claim for relief based on nuisance or trespass. And nuisance or trespass is defined, so it only relates to nuisance or trespass, not a lot of those other compatibility concerns that I talked about. Next slide. So what is a farming practice? A mode of operation on a farm, and that's the first thing. What is a farm? And this is really key because this comes up an awful lot. A farm is any facility, including the land, buildings, water courses, and appurtenances thereto, used in commercial production of crops, nursery stock, and so on. That is very key. Right to farm does not provide immunity or protection to hobby farming. If there's no intent to make a profit in money, if it's not commercial, it is not protected by right to farm. And I would say a big part of the complaints that we get relate to somebody that's got 2 horses and a cow, and the people next door don't like the odor and the like, and there's there's no sale going on, there's no intent, it's just for private use or the like. And basically I tell the person there that right to farm doesn't apply in this case, and that works both ways. Right to farm again is, and we're going to talk about this a little bit more, is not a regulatory action. It talks about civil actions in court and nuisance and trespass, and we'll get into that. So, but if it's not commercial production, it's not a farm and it's not protected by right to farm. Next slide. A mode of operation on a farm and so you've got to meet these criteria to qualify for right to farm also, is or may be used on a farm of similar nation, so of similar nature. So this is the practices we're getting now, is generally accepted, reasonable, and prudent method for the operation of the farm to obtain a profit in money. So there's that profit in money again, but look at those terms there: generally accepted, reasonable, and prudent. There's a lot of non-definition there, so there's a lot of interpretation. Is or may become a generally accepted, reasonable, and prudent method in conjunction with farm use. So let me give you an example of something historically we dealt with that didn't come out to be an accepted farming practice or a reasonably prudent one. We had a situation down in Southern Oregon where someone was using a propane cannon next to the urban growth boundary. And the neighbors, of course, were really complaining about that and the like. And as we investigated that, we found out the landowner saying, well, we're using the propane cannon to control rodents. That's not common and accepted practice for controlling rodents. Now, of course, that's not for us to determine, but as you know, the agricultural department, we advised the mayor down there that we didn't believe that would probably be found to be an accepted or common practice. Well, as we dug into this, we found out that the landowner had just been denied an urban growth boundary expansion onto his land, so he put the cannon out there just to basically spite all those neighbors and the like. But this was, this got into the right to farm realm because use of cannons in certain circumstances is definitely an accepted farming practice. In this case, it wasn't. So there's that determination that has to be made on a case-by-case basis. Next slide, please. A mode of operation on a farm that complies with applicable laws and is done in a reasonable and prudent manner. So might have an agricultural practice going on and they have a CAFO permit. They're not in compliance with their CAFO permit. They're not protected by right to farm. So on a farm that complies with applicable laws, could be water quality laws, could be, it might not even be a land use related law, but complies with applicable laws and is done in a reasonable and prudent manner. And there's that term reasonable again. And that's my experience, that's very open to interpretation in some cases and the like. Next slide, please. Definition of farming practice also includes the transportation or movement of equipment, device, vehicle, or livestock on a public road if the activities are conducted in a reasonable and prudent manner. And this is important, especially during harvest season and the like. You'll see a lot of equipment and the like out there, and we have had some situations where I've gotten calls where we've had some issues with something with a wide header, something that's going 5 miles an hour down the road and there's 400 cars behind it or something, and people, really complaining about that. And I just, hey guys, this is an accepted farming practice. In fact, more times than not, when I've dug into a case like this, I historically look at the road and it was originally approved as a farm to market road. And it's really interesting to look into the history of some of those kind of things. So this is another element of right to farm that a lot of people forget about. So next slide, please. Then, of course, what is a nuisance or trespass? If it's not a nuisance or trespass, it's not involved in right to farm. Nuisance or trespass includes, but is not limited to, actions or claims based on noise, vibration, odors, smoke, dust, mist from irrigation, use of pesticides, and use of crop production substances. So this is really about things that occur on the farm that might, in effect, leave the property in one form or another, as opposed to compatibility issues coming from off property onto the farm. It's usually the other direction around and such. So nuisance or trespasses are these types of things. It's not some of the other land use compatibility statements that you all deal with. Next slide, please. Location. Again, I mentioned this earlier. It has to be on land zoned for farm or forest use. Interesting thing here, it doesn't say on lands zoned for exclusive farm use. Now, this is going to be something that someday a court's going to have to interpret, but this can be read to say if the land allows farm use, then it's zoned for farm use, because those are all lowercase. It's not zoned for exclusive farm use, which is a term that the legislature uses when they really mean just the farm zone that's in statute. This is all lowercase. And the reason this gets important is you get into a lot of rural residential zones in Oregon, and farm use is an outright permitted use in those rural residential zones. So the question is, would right to farm protect commercial farm use in a rural residential zone? I could make that argument both ways. So this is going to be something that's ultimately going to have to be, will be determined by a judge unless it's better defined one form or another. So next slide, please. This is important here, and the reason I've got this lined out: no farming or forest practice on lands zoned for farm or forest use occurring outside an urban growth boundary was the old statute. The change that was made about 5-6 years into right to farm deleted that. And so that in effect shows that the intent of the legislature was that if you're conducting farm or forest practices and it's allowed in the subject zone, even if it's inside an urban growth boundary, it can be protected by right to farm. So that's something that led me to also think that it isn't just about exclusive farm use zones, it's about other lands that may allow farm use outright, because the legislature did delete that section about inside urban growth boundaries. Next slide, please. Immunity is provided if, so these are the elements that we went through. So these are the qualification elements, and I just want to go through them real quickly. Immunity is provided to a landowner if it's consistent with the definition of farm use that we discussed, if the lands are zoned for farm or forest use, if it complies with applicable laws, regardless of change or interruption of use. And let me pause on that real quick. In other states, they did not right the farm the same way we did in Oregon. If you, let's say you started and you had a wheat operation and you took the wheat out and you planted an orchard. In other states, Washington State, for example, is happening. That's a change of use and you're no longer protected by right to farm. In Oregon, because of our link to the land use planning program and the definitions of farm use includes a whole myriad of things, whereas in other states, right to farm was specific to the use on the land at the subject time of when it was adopted. And so we've had situations in Washington State where they've actually changed from one farming use to another farm use, and the courts have ruled they weren't protected by right to farm anymore because that was a change of use. We don't have that situation here in Oregon, but it's, and we, that's why we also have that element that we put in there regardless of interruption of use, so that we also it also recognizes you might discontinue farm use for a period of time and then bring it back in. It might sit idle and not just sit fallow, but just sit idle. So it recognizes that. So these are all the elements that you qualify for right to farm, except, next slide, regardless if you met all those factors, but you're not provided the immunity if there's a damage by your farming practice to commercial agricultural products. So let's say something that you were protected by right to farm, dust or something like that, damages somebody else's commercial agricultural practices, you're not protected by right to farm. Or it results in death or serious injury, the practice results in that, you wouldn't be protected by right to farm under the statute. So those are the, I guess, for lack of a term, exceptions to being protected by those factors in the immunity section. Next slide, please. So let's switch from the immunity section to local government regulation. Any local government or special district ordinance or regulation now in effect or subsequently adopted that makes a farm practice a nuisance or trespass or provides for its abatement or nuisance or trespass is invalid. And I think, Lauren, you remember this when we had, it was actually, it was in Malheur County, they had passed an ordinance that that the odor from mixing potato mash and the like was a nuisance and thus had to be stopped. And we had to remind them that they couldn't do that under the law. We've had that situation come up with some livestock operations in the Umatilla County area also historically. And we just, you know, again, we don't enforce anything here, but we just kind of reminded the local governments that this is in statute and the like. This applies to practices that would otherwise meet the test. So if you have a practice that doesn't meet the immunity qualifications of like, local government may regulate it. Now, if you look at this, it's really, really important to understand this relates to local government regulating for calling something a nuisance or trespass. It doesn't preclude local government from using land use regulations to regulate farming practices for health, safety, welfare things. And a great example of that is floodplains. You know, you put a farm building in a floodplain, you've got to comply with the zoning code for floodplain management. That's not considered a nuisance or trespass regulation or the like. So next slide, please. So right to farm issues. Right to farm does not preclude somebody from filing a lawsuit against you. Even if they're, you meet all those qualifications, it's still got to be decided ultimately by a judge in circuit court. So you're still going to end up having to defend yourself sometimes, even though you probably might qualify for right to farm. So that's one of the issues. So that basically comes up that the farmer is going to end up to defend, and there's going to be a cost associated with that. Now, right to farm does provide for legal costs to be paid to the prevailing party. It's happened a time or two, but more times than not, you don't get the cost. The judge just doesn't do that. So that's something that's still an issue also. Next slide, please. Right to farm involves a lot of interpretation. You remember we talked about reasonable and prudent and, you know, some of those types of things. And so that's a real issue. I've talked with past directors about this a lot, and, you know, discussion of whether or not there should be some rulemaking done, for example, to better define some of these terms. But right now, those terms are basically defined what you saw in the presentation. And so there's an awful lot of interpretation. That interpretation is going to be by a circuit court, by a judge, many times that knows nothing about agriculture. I was a witness in a case in Hood River County many years ago. I was the only expert witness in the case, and the judge still ruled against the farmer just because, in his opinion, it wasn't right. And it got totally reversed when it got to the Court of Appeals. But that cost the farmer a lot of money to take it all the way up through the Court of Appeals. And so interpretation by someone who has no understanding of agriculture or the like as opposed to it. And because it's a nuisance or trespass, that's why it's in civil court. But there's nothing in the statute that says it couldn't be reviewed by another body if it was established through rulemaking. So like a tribunal that might be a 3-panel board of experts in agriculture, and a lot of states do it that way. Actually, they have a review panel that way. But in Oregon right now, because it hasn't been developed in that part of the statute, it would go to circuit court because nuisance and trespass are civil matter cases. Legality. A lot of right to farm cases around the country have been found to be unconstitutional, and they've been found to be unconstitutional because they are called a blanket easement over the entire area, just basically saying these guys are protected, but the other people are influenced by the use are not protected. And it's just kind of a wholesale blanket. And so the courts have argued or have found in some cases that that's a takings because there's really no nexus. It's just this blanket catch-all type thing. I'm not a lawyer, but I've been around land use and right to farm a long time. And I think Oregon would have a much better case standing up against something like this because Oregon's right to farm law is tied to zoning. So it's specific to certain types of land. It's not just a blanket over all lands and saying if you got a farm use and the like. And so now all of a sudden there's a planned use of land. It's focused on that use and it's went through an actual planning process. And I think that would go a long ways towards Oregon's having a better chance to stand a legal constitutional test than they have in other states. And then lastly, this is something that we deal with a lot at ODA when we get these complaints, even though it's not regulatory. If farmers aren't good neighbors and don't work through some of these issues with their neighbors, this is, you know, right to farm could be right back in the legislature. And we all know that when you get in the legislature, you never know what's going to happen. Right to farm could be weakened. It could go away. It seems like every other year we've got some legislator that's calling and talking to me about what does right to farm do, and gee, maybe we need to change the law. And I'm, you know, always kind of just going on, you know, kind of thing. But it's important to understand that we still, as the agriculture community, need to be good neighbors and try to work a lot of these things out. And I had a great example actually down in your neck of the woods, Brian. I had a farmer call me up, a neighbor called me up who was dealing with a hazelnut farmer during harvest, and the dust was flying through, and he called and wanted to understand right to farm. And I explained it, and he said, oh, that's great. I'll just go over and talk to the guy and see if he'll just let me know, you know, before he starts to run the harvesting equipment out there so I can close the windows in my house. You know, so once he understood what was going on and what right to farm was, he was willing to, and the farmer said, yeah, I'd be happy to do that. And that's the kind of thing we have to do to make sure that right to farm works, I think, and doesn't become, doesn't become this political football, so to speak. Next slide. So, right to farm does not protect the farm from off-site conflicts. I talked about that before. It's more about things coming from the farm onto other lands. Does not preclude a jurisdiction from regulating farm use from a land use perspective. We talked about that, like a floodplain management zone, for example. Right to farm does not recognize competing primary land uses and transitional edge areas. And this is the area where we really get into some questions. So you've got exclusive farm use zone land right up against an urban growth boundary. Both zoning districts have legal primary uses. The urban uses that's the primary use, the farm uses are the primary use, but on that edge, you've got that conflict. And so it doesn't recognize that there may be some differences of how things should operate in those areas where you've got two competing primary uses. Out in a farm zone where you have non-farm uses located within the farm zone, that's not the issue, because the primary use is agriculture and the other uses are all secondary. But when you're on those edges, that's where you start to have some of those policy type of discussions, is what use has rights when they're both primary uses and it's on the edge. So that's something that Right to Farm doesn't really address also. Next slide. So I just wanted to talk a little bit about marijuana and hemp, because it's looked at a little differently under Right to Farm and land use than other farming practices in the state of Oregon. State statute basically specifies that cannabinoid products do not include industrial hemp. So separate from hemp, even though they're all cannabinoid products, in terms of some scientific types of things, state law divorces hemp from those other cannabinoid products. That's going to be important here in a second. State statute is silent on the regulation of industrial hemp. It doesn't say anything about local governments being able to regulate industrial hemp. But it does say that local governments can regulate marijuana growing for time, place, and manner. So that's a big difference between hemp, and you're going to see where I'm going here in a second. The legislature did not provide for local government to opt out of allowing for any land use related to recreational cannabis or for citing of medical cannabis. The statute is silent to hemp. And what I'm getting back at is the legislature, when they were dealing with marijuana, basically started to say, you can do this, you can do this, you can do this. It's separated from, they have different land use standards for cannabis production in terms of processing and the like, marijuana versus hemp. And so, whereas on hemp, the legislature basically said it's an agricultural product. And what I'm getting at is hemp has a lot of the same protections as any other farm use. Marijuana does not, in terms of right to farm. And that's a roundabout way for me to get at that. And but I think, Lauren, you remember the case we had with Douglas County. They were trying to regulate hemp production because they were saying it was the same thing as marijuana. And we had to go through, I had like a 2-page letter that we ran through the legal folks that we ended up making these kind of things. The legislature distinguished between the two. So, my bottom line is hemp is an agricultural product, like everything else in agriculture. It's a farm use and stuff, and it's got the same protections afforded by Right to Farm and land use as most other farming operations. Marijuana does not. Marijuana can be regulated despite Right to Farm, despite some of the other things in statute and the like. So next slide, please. And basically, that's what I was saying here. The key here, the legislature declared that industrial hemp is an agricultural product that is subject to regulation by the State Department of Agriculture. Marijuana is subject to regulation by local government and the OLCC. So again, those types of, so hemp, when we're talking hemp, and boy, when it first came out, and there was that big land rush of hemp or whatever, we were getting calls all over the place about the odor of hemp and some of the agricultural practices and the like. And we'd gotten similar calls to marijuana, but with marijuana, that had regulatory authority, and local governments were regulating hours of lighting and things like that. Whereas with hemp, they couldn't do that. And so I wanted to bring that up because there for a while in the gold rush days of hemp and marijuana, we were dealing with this an awful lot. I probably was on the phone 25% of my time just talking about these issues and the like. So next slide. Not going to move, Carl. I
think it did move.
Okay, let's go to the next one. Yeah. And yeah, so this sounds very legalistic and the like, but bottom line, Right to Farm is not a blank check. There are qualifying elements that you have to meet to be, to be provided that immunity from losing a lawsuit. It doesn't stop a lawsuit, but it provides you that immunity when you get into court, as long as you meet within those factors we discussed. Right to Farm is a complementary statute to Oregon's land use planning law. They work in different arenas, but they work together also. And it's important that those things work together. Nuisance and trespass versus conflicts. Land use does the conflicts. Nuisance and trespass is right to farm, and so they work well together. And I'll just stop there and answer any questions that you might have.
Miguel Lopez for the record. So Jim, are you seeing more and more, as this comes up, I think this is coming up more often than not, issues with agritourism in all parts of the state? Let it be a pumpkin patch, a vineyard, winery, an event center, and whatnot.
Yeah, Miguel, the agritourism is one of the more controversial non-farm uses that we deal with in land use, and it's been particularly problematic in the last couple of years. There's been several court cases that have come out where the courts have found that the tail's wagging the dog. For example, the agriculture was just an excuse to do a commercial use, and that it was the primary use, not the agriculture. There's, in fact, LCDC is meeting today. They're going to be talking about that a bit, and I'm going to leave here and get online with them on that. But it is problematic. For every farmer that's wants to do agritourism, I'll show you 10 farmers that don't want to farm next to it. And because most of the calls I get about agritourism and problems are not from rural residential types, it's from adjacent farmers and ranchers. It can be a very important and complementary element to a farm. I think the key is going to be there's got to be some better definitional elements made to the existing statute and administrative rules. There are multiple elements within the Oregon Land Use Planning Program that people try to use to approve agritourism related things. I mean, there's an events statute in the land use statute. There's home occupations that are used. I've seen people try to approve agritourism things as parks, for example. I've seen people try to approve hotels as a 2-unit bed and breakfast, and it ends up having 10 rooms in it or whatever kind of thing. So it's something that needs better definition. People always wonder why the Oregon land use planning regulations are so complicated. It's because of things like this. People try to find loopholes, and we have to go back in and define things, and it just makes the statute longer, but it also makes it more definite. And remember, with right to farm, that we have some of those terms that are very need some definition. Well, I would say that's what needs to happen here too. There's also a lot of case law out there related to agritourism that hasn't been codified. So it hasn't been actually put into the rules. So case law is applicable, but people, the day-to-day application of it by county planners and by the general public, they don't go and read case law like I do. So that case law ultimately, I think, is going to need to be put into the statute or into the administrative rules, so the people that administer this, the county planning departments alike, can see it right there in front of them.
Perfect. Thank you.
Yeah, Chad Allen for the record. Jim, is there any examples where odor hasn't been held up by right to farm?
Let's see. I have had some odor cases over the years where I've discussed it, and it's never really gotten to court. They've ended up being able to work it out or discuss it. The cases that have had actually some of the biggest odor cases that I've seen are not what you would expect them to be, the dairies and the like that you would think, whatever, because those are generally, well, you know this better than I do. It seems like about every 5 years I get a call from people inside the city limits of Tillamook complaining about, dairy smell. Well, the whole county smells like that. It's not just in Tillamook. And I'm always reminding them that those dairies are on lands zoned for exclusive farm use. It's just a perennial situation, but I've never actually seen it get to the point where it's got into court, and probably because it's a loser in terms of a situation. That's why I'm more worried about it, not a judge ruling against that, but something coming in to the legislature, something and trying to regulate that. And that's what we've got going, with the poultry operations right now. There's a call again to regulate for air quality. And air quality versus odor, you know, they can be related, but they're not always the same thing either. But I'm not familiar with any case where a farmer has lost a odor-related complaint. The one or two that I've seen, the farmers won.
Okay.
Elin Miller, two things. One, since it's been 10 years since this board has seen this presentation, I'm wondering how long it's been since different trade associations have, and even making this recording available to folks. You know, again, refresher, there's a lot of new people in the industry, a lot of folks coming in, just for reminder.
I give this presentation to a group of students that every year that are come out of the Dairy Association. Tammy Kerr has a situation where she brings these young farmers or students in, and I give the presentation to them. But I haven't given the presentation to any of the larger organizations in a while, kind of thing. And so I do the same thing with another one I call Farmland Protection 101, which goes to the land use side as opposed to the right to farm side too. So. And I haven't done that in a while either. So,
well, since this is recorded, I was just wondering, you could just awareness posted, make people know it's available. I thought it was a great presentation. And the second one, the tribunal panel that you mentioned, it sounds like that would have to be a statutory change, or could that be done through rulemaking? Should anybody ever decide that is a way to go?
Stay away from that because I didn't want to get Lauren, but the statute actually provides for the Department of Forestry or the Department of Agriculture to do rulemaking should they want to.
So that could be an implementation, not a, well, anyway, it would be a question to ask DOJ.
Director Koba and I used to talk about this all the time. We had some situations actually where we had conflicts between farm to farm, and there were some nuisance things. And the issue we had there was trying to better define what are common and accepted farming practices. So this wouldn't have to be done on a case-by-case basis, but we could actually put in rule, if you're doing certain things this way, and this way, you're protected. So it's in rule that is a common and accepted practice as opposed to that being determined on a case-by-case basis. It's a slippery slope. Rulemaking is always, you know, how far do you go before you're impinging into the legislature's authority? When you're dealing with a farm state like we have, where you're producing 220 plus different commodities, so you can multiply that by 10 or 15 in terms of how many different agricultural practices we have. It really starts to become onerous in terms of how to define that. But I've seen, you know, the state of Michigan, for example, has taken some of the primary crops, you know, where everybody agrees these are common and accepted farming practices, and they've listed them in their deal. These are common and accepted practices for these crops, but they've also left it open to make determinations on a case-by-case basis for other practices, for new practices and the like. I think it's also in the state of Michigan, they actually have a 3-member board that Right to Farm complaints are brought in front of, and I'd have to go back and read that, but I don't remember if it was appointed by, you know, the governor, or I think there was a tie into their agricultural commission actually, so.
Yeah, if I could, Lauren Henderson, we have always thought around the creation of an arbitration panel or something, what Jim had talked, that because there are other statutes that guide the practices around how the court system appoints those, for ODA to do rulemaking that isn't connected legislatively to those would not probably work very well. In fact, it might work just the opposite, and then that becomes a challengeable issue on top of the others. If that was ever a desire, which I don't think we've had come up in the legislature that I know of, it really should be created in statute and tied to those other processes. I will just say to your comment about the 10 years, there isn't a good enough breadth of knowledge around right to farm and what it is and what it isn't. And Jim just wrapped it up in a couple of sentences. It does come to us pretty regularly. You all may think about it yourselves. I will just say, I hope you were all paying attention. If Jim decides to play golf on me 7 days a week, I need more people in the department and around us, including some of the folks in our partners, to understand what it is and isn't, because it is not well understood. Jim is by far the expert on the issue, and we should put that out there. And Jim, I don't know if you remember, you had a 1 or 2 pager on Right to Farm. I remember. I don't know if we have that on our website.
It's on the website.
So maybe we need to put that in a more prominent place for people that we can point folks back to.
Yeah, and Elin, the tribunal thing, Lauren is dead right on. A great example of what the state did in a situation like that. When the Oregon Land Use Planning Program first started, land use cases went to circuit court. And they found out real quick that was very problematic because number one, there's a lot of appeals and like whatever. So they created the Land Use Board of Appeals. The legislature created the Land Use Board of Appeals, and that's all they do is hear land use cases. So, if this were to become a real issue, something similar to that kind of thing could be set up by the legislature as an example. So.
Thank you. Develops for the record. So Jim, to me, it almost seems like this should be part of Real Estate 101 for the state of Oregon as well.
Yeah, Miguel, I don't disagree. Some counties have actually, when people come in and start questioning about lands on rural lands or whatever, they have a document they'll give them that's kind of a rural lands 101 type thing. It talks about things like, conflicting uses and being compatible with farm and forest uses. What is a septic tank? Water rights. All these things that rural landowners need to know about, and that all of us, it's just second nature. But somebody moving out there doesn't have a clue. A great example is look at all the marijuana growers that got out there didn't know they had to have a water right. They just started irrigating out of a kind of thing. Things that we all just take for granted. And so many counties do have a document they hand to people, but real estate folks really need to be better educated on that. Also, when I was a county planner, I couldn't believe the things that people would come in and tell me that their real estate agent told them they could do in rural lands and the like. And so, and it's just it's not anything that's malicious or anything. It's just they just don't know. So. Yeah.
The tractor on the road thing has been cracking
up. We had a right to farm case in Washington County where a guy was moving his swathers down the road, and there was an accident associated with it, and the people sued, and the farmer argued he was protected by right to farm, but because of that physical harm element in right to farm, that part was the immunity wasn't granted. And so it is a real issue, and especially in the Willamette Valley, where we've got so much urbanization, and you put that equipment on the road. I mean, I've been out by Josh's farm. I grew up out by Josh's farm or whatever, and I'm driving on Hazel Green Road. I see your vehicles going back and forth across the road because your nursery's on both sides of that road, and that's basically turned into an urban road now, even though it's outside the urban growth boundary. I just wonder someday somebody's going to hit one, kind of thing, and that's the kind of stuff we all have to deal with. So.
Yeah, I just myself an example here in the valley. We'll hear of somebody moving a tractor, and these are just specialized little tractors. So you either have a flatbed or you don't, or you're just moving it down the road really close. And there have been instances where accidents have happened or are really close happening because somebody was impatient.
When I put myself through college doing farm-related work, and I used to have to drive swathers. Actually, we didn't put them on a truck. We would just road them from one field to the next. I was cutting sweet peas. And there was a time or two where I was almost run off the road, but somebody's trying to pass you as you're roading that thing. And I remember taking a mailbox out one time because I had to swerve to get out of the way of the crunch. So it's a real issue, and it's a very real common issue. And when I give my land use presentations, I have a slide where I show a large tractor and a disc in the slide, and there's a line of about 20 cars behind it, and I just show people this is one of the impacts that non-farm development can have on farmers, their ability to move equipment, because as most farms are made up of constituent parcels. This isn't just one big square and they just can move within that boundary. They got to move from one place to another to their next project, and it's a real issue.
You touched on the, general residential boundaries being, and I often think about that. I mean, I think about it every day.
You guys are up against the urban growth boundary there, yeah.
Yeah, but the farmer to farmer thing is kind of interesting. One farmer not wanting another farmer to do something on their land. And I think within the Willamette Valley and probably all throughout the state, I think we're going to start seeing more people trying different crops. And you mentioned the chicken farm out there, or probably the one out in the Staten area. I'm just kind of curious if they're going to do that operation out there and play within all the rules in terms of, pollution and whatnot. Is it really realistic? I mean, is there some kind of permit or something that they're trying to get? They can't do that there? Or, I mean, you don't have to talk about that specifically, but just that part of the right to farm is very interesting to me.
Yeah, there's really two elements to a situation with these large-scale livestock operations. One's the land use element, and the other's the environmental regulation. And with the poultry farms, a lot of the argument is philosophical arguments against scale of farms versus actual operational characteristics. This is a factory farm. Well, some of you've always have heard me say that agriculture basically is factories without walls. I mean, in this case, these operations actually have walls, so kind of thing. But we are dealing with the poultry farms in that we have to issue CAFO permits. But before we issue those CAFO permits, we go to the local government and get what's called a land use compatibility statement determination. Does the zoning allow the use? And of course, in the case that Josh is talking about out there by SIO, it's zoned exclusive farm use. And farm use talks about raising livestock, chickens, poultry, all that type of thing. And it doesn't say anything whether it's 5 chickens or 5,000 chickens, it's farm use. So the land use itself is permitted outright. Where we get into some of the pushback and is that some people think that scale of farm, after a certain scale, it shouldn't be allowed in a farm zone, even if it's zoned farm use. That's not up for us to determine. That's a policy decision. Now, some of the other concerns related to water quality and water supply and air, those are environmental permitting practices. That's usually not a yes or no determination. It's a how determination. You mitigate it with conditions like if you can't, then you deny. But whereas in land use, it's more of a yes or no. You allow the use or you don't. In environmental, a lot of times it's more mitigation, conditions and stuff. And we do conditions in land use too, but generally not for permitted uses, we don't. So that's what's going on out there. I mean, the blowback that you've been hearing about from ODA is a lot of people think that ODA should just not be allowing it because it's not a farm use. That's not up to us to determine. That's what the zoning does. We're looking at, can it comply with its water quality requirements under a CAFO permit?
I think that's going to be an interesting watch.
I don't know if we have questions from the people joining us remotely. Do we? No. Okay. I think you don't have any more questions. Thank you very much.
Well, I just heard Lauren say I could start playing golf 7 days a week. So
No.
Thank you all. I think down the road we might want to talk some more about some of the other land use things, and I'll talk to the director's office about maybe getting that down the road on another agenda or such. So I can just sense you've got questions about. I mean, agritourism could be one presentation all by itself. So, thank you.
Thank you, Jim. All right. So next point in our agenda. Okay. We will begin the public comment period for this morning, and we have one person that is going to join us to verbally. Here is Dave Lodge. Please, thank you. We're trying to be limited to 3 minutes, but I don't know. Yeah.
Good morning, Chair and Board. My name is Dave Losh. I work as the state statistician for USDA's National Ag Stat Service. A little background, we do all the crop and livestock statistics for Oregon, and we're part of the Northwest Region Office, which is based in Olympia. My primary work is dealing with data requests and trying to alert producers of our annual survey program and what it means to participate and where the numbers go when we ask for data. I'd like to bring you up to speed on a couple things we've got going right now. The big one is the Census of Agriculture. 2022 is our reference year. We do it every 5 years. It's the most comprehensive data set on agriculture in the United States and in Oregon. It's primarily a demographic survey as far as who's farming and then where they're farming. We publish where we can acreage and value down to the county level. And it really lets a lot of folks know where the changes have happened since the last census. For example, last census, we saw a lot more female farmers getting into the industry, or we did a better job counting them. So those types of things, and what are the policies? Ever since the last census, we've been working on building our lists and getting them right, and really emphasized a lot of the BIPOC organizations and trying to capture new folks that are coming into agriculture and maybe in some non-traditional ways. Just a quick reminder, we count everybody. The definition of a farm for us is producing or would normally produce $1,000 worth of product. That's an old definition, has a lot of political ties to it, mainly from the Midwest where there are lots of farms and everything's nice and square. The census will be mailed in early December and with a due date of early February. We know folks getting their books done and everything that's not going to happen. We will send out reminders and then we'll have a follow-up period and we'll end up having our data collection go into just about May. And then at that point, we'll be doing our analysis work, just a ton of work on our part. Some folks will not be necessarily mailed their operation if they have involved in multiple operations. So say you have one farm entity and then you're farming with your brother or your dad or somebody like that. We need to coordinate all that so you don't get 3 separate mailings and things and you're sitting there going, why did I get 3 of these? We encourage people to fill it out online on the web. It's a secure platform we have, and it will allow you not, once you tell it up front what you have, then it routes you through. So if you don't have any livestock, you don't get the livestock questions. So we're trying to make that better. We had it last time, and we're really learned a few things, and we're made improvements. Last month, I visited the Department of Ag building, first time in a long time, and visited with Andrea Cantu-Shomas about help publicizing the census and making people aware of it. I mentioned to her that this time I was going to try and maybe work through Chris Anderson to go get the commissions, have a message go to the commissions to make them aware. I regularly attend commission meetings. There are a lot of them I can't get to, and those folks on the commissions change. So that's a new approach this year. Also working with Andrea on our facts and figures brochure because we had the person that I used to work with move on to another opportunity, and also working on the annual stats is put out by ODA. So I'm just happy to be here and seeing everybody's face and get to meet some new folks. Thank you.
Very well. Thank you. Thank you. And now,
Thank you, Dave. I just wanted to make one brief announcement. We did receive an additional written public comment from Grant County Soil and Water Conservation District regarding the ODA DEQ MOA that I will distribute and post on the website as well.
okay, thank you, Carla. Okay, I think we have finished the public comment right now, and we will go for a break before we start our business. So we have 15 minutes. 10 o'clock will be okay? 10:15? Oh, I'm sorry, 10:15. It's already almost 10. So let's do 10:15 to come back, just to keep in the schedule. 10:15, right? That's what we said.
Absolutely, same.
I would train you to do this. Yes, you're good. All right, Luisa Santa Maria for the record. We're going to continue with our agenda for today's meeting, and we're going to board business. Going to talk about the ODA program area reports. Have the chance to review it. Any questions for ODA staff? No questions for the members?
Yeah, Elin Miller, quick question, hopefully, and I had asked the question offline too on the grapevine test or mealybug question. Actually, I didn't ask about that offline, but and also there's one on the grapevine certification program, just to kind of put on the record what the plant health program is doing in that area. I just wanted to specify, because there have been some questions in the industry of the involvement of ODA in that.
Okay, I think we can have the right person to follow.
Chris Benman, Oregon Department of Agriculture, for the record. Elin, could you repeat your questions, please?
Yes, so just if you could just give us a little bit more intent about strengthening the oversight of participating growers to ensure clean grapevine nursery stock aligns with the Clean Plant Network and the work you've been doing on that and you already have in place.
Right. So a lot of this has been spearheaded by our plant health program in particular. So nursery, as we oversee any nurseries in the state that do sell grapevine material. So we're kind of on a sidelines helping with that. And also because our plant health program oversees our certification programs and any other phytosanitary standards. So really the impetus for this was kind of been a multi-year project in collaboration with other grape producing areas like California, Washington, and Idaho in particular, just to harmonize our various phytosanitary standard measure requirements for imports and exports. So part of that for at least our grapevine quarantine, which has been in place for a number of years, was just bolstering those standards. Really, that was done in conjunction with advice from the Oregon Wine Board in particular, really pushing forward the requirement that all incoming grapevine material would be sourced from certified programs. Again, in efforts to protect our wine growing industries from any unwanted pests and diseases. So that went after many, many years of discussions at the table. I think we had that go live. I want to say that was last year, I think, if my memory serves me correctly. And there was kind of a phase through system part. So first we were going to say, okay, I wasn't prepared to answer the dates for this question, so I apologize. But at least by
generalities.
Generally speaking, the first phase was just saying, okay, just make sure that you're testing meeting our requirements. Go back for about 2 years to test your mother vines to make sure those are free of diseases. And that was to give growers time from our exporting states to get on board, do whatever transitional changes they needed to do in order to widen their base for qualified product. Then starting in 2023, we were then implementing the requirement like, okay, you've had the 2 years. Now we're going to go through, you need to come from a certified nursery in order to ship into Oregon. So that's kind of the process we've been doing with the quarantine. And then did you have another follow-up question?
And then you're also doing some mealybug work too.
Correct. So earlier, I think it was late last year, early this year, we did find vine mealybug in 2 Southern Oregon vineyards. And that was a product of just trapping that actually Oregon State was doing in the area. And then they notified our entomologists. And so they were working together to figure out, okay, where did this come from? That we still don't know. Potentially that they were vineyards who had brought in perhaps uncertified material from out of state. And that was how it was introduced. That's typically how we get most of our invasive pests, unfortunately. We did go to the Oregon Wine Board and applied for some funding because typically when we find a new pest, our first line of action is to do continual surveys to determine the spread. Because in order to we need to know how far widespread any individual organism is before we can really come up with an action plan. And unfortunately, we don't typically have a ready standing source of funding for immediate response. So we need to be very conscious conscientious about how we develop our actions, how we're, utilizing our existing resources, and if we need to go ask for additional funding, what are we actually asking for, right? So we had a small amount of funding from the Oregon Wine Board that has supported some continual surveys throughout this summer. I think we've collected all of those traps, and our initial screening of those is that we think we have a third vineyard that has been found by mealybug and possibly some other areas, but we're still collecting the data on that. So in terms of second steps, once we get the final kind of numbers of what we're looking at, obviously reaching out to industry to kind of ask, this is a situation as we know right now, what additional steps would you like us to take? How are you planning on individually responding? Because again, with these individual locations that were found to be infested, our recommendations have been, providing restrictions on movement of material, because within our existing quarantine, we do have authority to establish a limited quarantine around any infested site, which prohibits the movement of materials from the site. We require sanitation and treatment methods to have to be implemented directly on those sites in order, again, to prevent the spread of those pests, in this case by mealybug, from spreading to other locations. I lost my train of thought.
Would there be, from a future project funding, whatever, what do you anticipate there if?
Yeah, that's kind of where I was going. Thank you. So one of the other things is, so we already have a couple of grapevine-oriented federal grants that our plant health program has. So there is funding for us to do some testing, because with vine mealybug, it is a vector of leaf rolled viruses that we also don't want. So that was kind of my primary questions is, if we have these mealybugs, did they also come carrying these viruses with us? So right now I think either this week or next week, we're having a meeting joint with nursery, our plant health program, and our entomology groups. I think they actually had an informal session yesterday to talk about, okay, what can that sampling look like? How much can we do? How widespread can that be? And then a timeline for that. Again, that will provide more data to see what are we actually dealing with.
And then any next steps you'd recommend after that, if you needed additional funding or whatever for the future?
I think that's the kind of question is is this established, or is this something that we can actually nip in the bud, right?
Thank you.
If I could, nip it in the bud, that's a good one. Lauren.
Nip it in the meat.
Yeah. Lauren Henderson, I just wanted to point out for the board, Chris, thank you. You just saw right in front of you what we have been talking about internal to our agency with our executive team. This conversation that you asked, Chris, was in our plant health program, which is in market access, and then it transitioned to the handoff of Chris's program in the plant protection program. And we're working hard internally to get the executive team at a level that they can be knowledgeable about all things in our agency. And Chris, you did a great job with that, but it does require us internally to think beyond our lines and to be in close communication when we have these things. And we're still working on where are those logical handoffs so we don't get stuck. And that's always going to be a work in progress for us. But you just saw it. You've heard me talk about that before, and this was a good example of that.
Well done. Thank you.
Thank you, Chris. Okay, so I think the next step would be a web report from Barbara, but she's not here.
Right.
So we're going to skip that.
Right. Barbara could not be at the meeting this morning, so we'll the double update from her in February.
Perfect. Okay, so the next will be the resolution work groups. And I don't know who can represent each of the groups we had, Group A and B.
So, Chair, if you want to go with A first? Okay, all right. Elin Miller, so we had one resolution left, and that was 319. We received some earlier public comment, actually public comment back in August, and that the staff did a great job of incorporating that. And then the new draft was out for public comment. We received basically some supportive public comment. There are some previous public comment we looked at. And so we just have some minor edits for it. And the minor edits would be in the first page, whereas, where we would second whereas from the bottom, add and need to weigh the benefits and burden of such policies after will affect agriculture. And this was sent out to the board Tuesday night. And then there was also another minor edit at the top of page 2 on that whereas of it would go from will to may. And so that's what we had go from our workshop on Tuesday night. We did have some additional comments that were made in the public comment period yesterday. And the question is, do we need it? Does that change any of this? And since these are ongoing and at any time anybody might want to make changes, I don't know what the pleasure of the board would be based upon the public comments that were made yesterday on, and maybe somebody can help summarize those for me. Was talking about, I think it was about efficiency and making sure practices continue to have high levels of production or even increased production when we're considering alternatives for dealing with climate change. So I know it's best since we've got comments coming in, and I looked again to see if there was anything like that in the resolution, and there isn't quite. But, you know, we could, as our work group, you know, just look at doing a quick edit, send it back to the full board so we don't have to reconvene the work group, or we can just wait till 3 years from now to deal with it again. So I'm not sure what's best.
We would need to reconvene another work group meeting. So the options that you have today are to approve what you've recommended here, or we could hold it over until the February work group session, or you can approve it and bring it up. You can bring it up before the 3 year cycle.
Oh.
So the 3 year cycle is the routine review of these resolutions. So resolutions can be brought up at any time for review and comment. So
well,
those are the couple of options to approve.
From what I recall of the comment yesterday, I don't see anything that's explicitly not in here. Like it could be added, but that could be, I mean, we could keep going forever. It's already a pretty long resolution compared to lots of them. Just my thought.
Well, it sounds like what we could do is move for approval with the minor amendments. And if we're motivated at any point in time, if it's a big enough deal, we can bring the resolution back and add that into the mix of our groups in 2023. Does that work for everybody? I just didn't want to miss something if there was. Okay.
Yeah, I think maybe we would need to call for a motion or.
Yeah, so I move to approve the resolution with the minor edits as presented.
Okay, so.
Second, Brian Harper.
Okay, so here in the second, I think we're going to follow the motion to accept as it is as after the review. Is that right? Oh, I need to vote. I'm sorry, I need to with the process. Yes, so I'm just reviewing first what we're saying, and then I'm gonna go for the vote, okay? Please, the members of the board, can you? In favor, say aye.
Aye. Aye.
Aye.
Aye. Everybody says aye. So here, somebody has opposed to this?
No, just ask for it.
Yes, let me see. All right, all those opposed say no. No, no one. And so in this case, we're going to motion passes, all right?
There you go.
All right, thank you. Our next point is you have the 2023 resolution. We have the 22 resolutions work groups in your packet. I think you have, no?
You have to we go to group B.
Oh, I'm Sorry. Oh, Group B. I'm so sorry. I was going to continue since we voted already. Yes, please. Group B. Thank you. Thank you.
Randy Savati. Group B, we had two resolutions left. We'll start with the farm worker housing resolution number 307. We just reviewed the final edits that we kind of asked, some updated numbers, some different wording in. The big one was updating the numbers. There was a few minor wording changes. The big thing that we did add was whereas refundable and carry forward tax credits. Right now that those tax credits are hard for some people to get simply because you can't carry them forward and they are not refundable. So the use of them was limited. So we did ask for that within the resolution, and I believe you guys got a copy of that. So with that, with those edits, I don't think there's any other changes if any other board members have any comments on it. Okay. So I'd like to make a motion to approve resolution number 307 with the edits as presented.
Second, Brian Harper.
Okay. So it's move seconded and for approval of this resolution. Now we are going to hold the vote for that. All those in favor say aye, and those opposed say no, but aye.
Aye.
Okay, so everything valid. All those, oh, I say that. Oh, those opposed say no. We don't have those. So the ayes have it, and the motion have passes now. Okay.
Randy Savati again. The second resolution that we worked on, had good conversation around, is the Oregon Department of Agriculture's role in the Food Safety Modernization Act produce rule implementation. We've heard a lot about this in last year. A lot of conversations. At the end of the day, we decided to not make any major edits to this resolution. With, I think, the information that we've received from Susanna and Casey and those, the resolution very leaves that, I guess, with the educational component intact, very much asking for that, but to give the ODA the ability to revisit it should the FDA update their rules, different things come down the chain, different things like that. So in the end, we actually chose not to make any edits. The only edits that will be made to this resolution is the basically the review date and who reviewed it. Other than that, no wording will be changed. So with that, I'd like to make a motion to, make a motion to approve resolution 317 with no edits other than the date of which we reviewed it.
Second.
Okay, so it's moved and second to approve the resolution 317. Do we have any additional discussion? If not, we're going to vote. All in favor say aye.
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 All those opposed say no. So then, well, oh, yes, so we will pass this motion. Motion passes. Right, are we okay? We have another resolution? No, that's all? Okay, perfect. All right, so now we continue with the agenda. Thank you. And as I was started to say before, we have the 2023 resolution work groups. And in your packet, I hope everybody found those memo with all the resolutions that will be under review in 2023. I think we need to consider, you have to consider which group you would like to participate in, and it's supposed no more than 5 members of the board can participate in each of the group. So I'm not sure we have to tell right now, we can think about it. Carla, do we have to mention right now which group one, or we can tell you any other moment?
No, if you would just review which work group you would like to be on and send me a quick email, I think that will be easier than trying to negotiate. on the spot.
Okay.
Just remember that we cannot have more than 5 members on each work group. So at some point, if all of you signed up for one work group, we would want to come back to you and switch some of you around. But if you would just send me a quick email on your preferred work group for next year, then we'll get the versions out for public comment and with our work group assignments in January, so folks have time to review before the February meeting.
Elin Miller, just a question from a process standpoint. Since there are so many important resolutions that are listed in both, and I realize this is kind of an every third year thing, if there's a board member that might have comments on a resolution that they are in that work group, can they submit comments to that work group versus just it coming up at the last minute when the work group brings the proposals? I don't know if that works or not.
I think previously the way that's been addressed is during discussion. After each work group or during the work group report out, I think that's the opportunity for board members to comment on the other work groups' resolutions, and before you take it to a vote and recommend edits to, for the next work group meeting to consider and review.
Jim Johnson. Historically, how we've done some of that too, Elin, is because there's no quorum issues when it's staff talking to members, is talk to the staff person for that work group too, and get your input in, that would help that staff person then to develop the discussion and that also. So, I've got 5 of these. I'm going to be busy. So, and I tell you, 3 of them are big ones. They're long ones.
No golf for you.
Thank you, Jim. That was helpful. All right. I think what we need to do now is to find some topics for the newsletter. You can mention something that you would like to have in the newsletter from our meeting here. What do you think would be?
Lauren Henderson, Carla, did you want to kind of describe what you're needing for the newsletter and timelines for people?
I would like to have topics from this quarter. You may have noticed that I did not get the newsletter out for the August quarter, for our August meeting, so I will combine our August topics and this meeting's topics in our newsletter. And then after we get that done, I can give you an update on the industry report status of that. So, and what we want to do going forward.
Randy Savati, Carla, can you just remind us what our August topics were? Sorry. It's in the minutes, probably. I'll look.
There you go. We were going to do a report out on the visit to the dam and the let me find that quickly.
I got it right here. Just looks like
Shipping Point programs, the FSMA update, board resolutions, tours, and the Grasshopper and Mormon Cricket updates that we received in August. We were going to report out on that, and then whatever we add from this quarter meeting.
Randy Savati, one of the things I think, and I would love, we kind of talked about even presenting to the board as well, but I think it's a good topic, even though we maybe didn't talk about it in this meeting, is the trade missions that ODA has gone on. Just a brief overview of where you guys gone and where it went and how you feel like those were received. Just kind of an update on ODA's role in that.
Yeah, Lauren Henderson, Randy, I think we could put something in the newsletter about them and where they went, and then we were talking about doing a follow-up in the June board meeting. So maybe that would be a good topic in the newsletter, just to tee that up for that next board meeting.
Eli Miller, the right to farm would be good to just say was reviewed again and just another angle for promotion. That information is available and a recording of it is available might.
And we
be
could also
helpful too.
point people to that.
The 2-pager or 1-pager. Yeah. Good.
Just kind of an overview of our visit to Aurora Extension, as well as Dr. Ivory, I don't remember his last name, his overview of the extension, remind people that's what it's doing.
That's great. I think with those topics and with the August topics that would be great for the newsletter. So we'll get that done.
All right, Luisa Santa Maria for the record. Or maybe, do you have some other, we have other board meetings. We talked something yesterday. Some, I don't know, Carla, do you have something in the list for the?
Just ask if there's other.
Okay, other board meeting, business, I mean. You mentioned something yesterday.
Yeah, Elin Miller, I think we had talked about the fact that the selection next step for the new Director of Agriculture is really, really important. And what role that this board could potentially have in at least lending assistance to the transition committee. And a thought might be that we would craft a letter that would go from our chair on behalf of the board to the transition committee to say, given the diversity of this group and the complexity of agriculture, we're at the ready to assist the governor's office in next steps and what makes sense for the Department of Agriculture, and just see where that might go, which might end up being someone on this group to serve on that selection committee potentially, or at least provide some input going forward, and not necessarily saying who or what, but just, again, have it offered. And I think there's some other boards and commissions that are doing that. And so that would be my suggestion. I don't know what people's thoughts are.
Lauren Henderson, we're anxiously awaiting what the transition team looks like, and then the follow-up instructions for what they're asking agencies to do. I would anticipate there's a lot of vacancies in agency heads right now in some places, and so they're going to have to figure out what they're doing there, and we will let this group know what that looks like. At this point, I think if the board would at least agree on the chair signing a letter like that, and then somebody would have to edit it, obviously, but then we'll figure out the who is, because I don't even know that we know who to send it to right now. And just a reminder, some agency directors are appointed by a commission. Think of the EQC, they appoint the DEQ director. ODF and W, I think, is forestry, and that this position is appointed directly by the governor. It can either happen through a direct appointment, it can happen through a nationwide search, it can happen a combination of both of those things. Or in the case where I'm at right now, I'm acting, and I'm going to be acting until I'm not acting, whatever that means. So just the board, I think it's important for the board to have a voice if they would like.
Do we need a motion to say we'd like to send a letter to that effect?
No, it's just something to be agreed. Okay. So let's kind of approve among the board.
Yeah, Randy Savati, I think we should, I mean, if we don't need a motion, I support it.
Right. Me too.
Yeah.
Maybe we can
I think it's a great idea. I mean, to get ahead of it a little bit, just show our support, show, kind of make sure we're part of that conversation.
I think it would be helpful to have someone on the board pin the letter, only because it probably should not be me. And it's difficult, I think, for staff, just to make sure that there is that separation in that, and then get it for editing. Obviously, I think Carla could help with formatting and editing and those kinds of things. But
I think Elin would be great at that.
Thank you. And would it be appropriate, again, with meeting stuff, if I did zip it off to a couple other people, keeping it under 3 before I send it to Carla for finalization? And then your signature, obviously, you have to review. So a couple you may be recruited. So anyway, just saying. I'll try to get that done this week because I've got to be out of town. And so I've got to get it done today.
When if everybody from the board gives something, maybe, oh no, it can read it and give something, or no, you want
Well,
just.
I don't know if that's,
short group?
I don't know if it's allowed with that many people on an email chain. So, so I'll be hanging around. So if you've got ideas come in individually, let me know. And then, yeah, that works. Okay. Yeah, because it is from the board. It is not from the team. So, yeah.
Any other business?
I had a question, I guess, in terms of policy. I guess I just need to have some clarity or some potential pathway that I know for me as a board member on here, that when we face issues that are legislative, not in our favor, how is a, Board of Ag here really have the opportunity to educate the legislators and the governor's office on the risk and concerns of those negative bills that would be impacting agriculture in the future.
Lauren Henderson, Jonathan, come on down. That is a very good question. So I'll wait till Jonathan gets here.
I just feel as that's part of our role, is to make sure that the governor's office understands certain bills that are coming up, how they would be impacting Oregon agriculture as a whole, and that and how we do that in a manner that is within our walls, I guess.
Yeah, so I'll just give the high level thing, and then Jonathan can help fill in the gaps. Given that you're all appointed by the governor, Jonathan and I, through the Natural Resource Policy Office, can always make those conversations available to the extent we can do that. We don't know who the new governor-elect Natural Resource Policy is yet. We will soon enough. We as an agency bring and flag those kinds of issues in what's called the Natural Resource Cabinet. And that's the natural resource agencies get together. That's pretty unique in the state, frankly. A lot of the other policies don't do that. And we're able to flag things of concern. As a reminder, through the legislative process, unless it's a governor's bill or one of our bills, we have a neutral position on those things. And so then our role and the role of the board becomes exactly what you just described it. Hi, I'm a board member for the Board of Ag. And I just wanted to talk about this and the issues. We don't lobby on one side or the other of those. There will be an opportunity in February board meeting. And it sounds like the board was interested in Jonathan and I arranging some meetings one-on-one with some legislators so that you can talk about your board report and those kinds of things. So Jonathan, why don't you take it from there on how to separate yourself and your role as a board member?
Yeah, so I think Jonathan Sanda, Assistant Director, Department of Ag. Chad, I think Lauren's right in terms of, I think in February, we heard interest on kind of organizing those meetings. There we can talk about issues facing agriculture all around the state, particular expertise that, each board member has, can bring those up, in those meetings. In terms of taking quote unquote official positions and lobbying one side of the way on policy, we will separate kind of the board itself as a unit, and then you as an individual, right, obviously are free to do and say what you can and want outside of as official board member, or speaking on behalf of the board. But then also I would also just, reiterate too that, you know, the board is here to, you know, help advise the department and those types of things. And so if there are issues that, you know, you are seeing that are particular concern to you, you have our phone numbers, you know, give us a call, make sure that we're connected to those things as well. That way we're aware of the issues, we can have those conversations. And then, you know, as we go through, if there's particular, you know, we're not just limited to February when we can, you know, schedule folks to go in to speak to members of the legislature too. If there's other times that board members are interested in going in and doing more informational kind of conversational approaches, you know, we can help facilitate those throughout session as well. That helps, Chad. Or
and where it gets where you have to be more careful, Lauren Henderson again, is you all have your own businesses and farms. That's why you're here, or represent that part of agriculture. This is not to say you can't go and say, hi, I am Lauren Henderson. I have Lauren's farm and I want to testify on X. You wouldn't want to say, I'm Lauren Henderson and I'm here with Lauren Henderson's farm and I'm also on the Board of Agriculture, because then, or on behalf of the board, because then people are not clear why you're there or what you're there. We would need, if the board wanted to weigh in on something in that neutral space, we would have to get clearance from the governor's office and run that up the flagpole to do that. And then the board would have to do that. So does that help?
Well, I guess I understand the two different sides of that for sure. But I guess, you know, moving forward, not always knowing, you know, what new legislation's coming up the pike that might be negatively influencing ag, just seeing whether or not we as a board, you know, would be able to have those conversations with the natural resource director, or to make sure that the governor's office, you know, got our collective opinion on how that would impact agriculture, not necessarily lobbying any particular legislator on that particular bill, but making sure that they clearly understand the impacts that it would have in ag.
Yeah, Lauren Henderson, Jonathan tracks all the bills that get introduced and we flag them for a couple of things. We flag them for, these are going to affect the Department of Agriculture, us as a body, and these are going to affect all of agriculture or have some impact, and certainly can share, I think, with the board that list of what we're tracking and watch them. The key to that is there's lots introduced and there's a lot that don't make it to the end. And so we don't get too reactive on bills, and the board probably wouldn't either until you start to see them get scheduled and get hearings, because a lot of them don't. But we certainly can share that. If there was something that got flagged as a board, we'd have to rely on Carla to help us on the quorum, and you know, it doesn't warrant an emergency meeting, or, you know, do all of that right and be very transparent, but then certainly could run that up through the governor's office and flag it that says the Board of Agriculture has a concern or wants to weigh in on X, and here's it is that way. There is, I guess what I'm trying to get is there's a process for everything, and we want to do it well and correct, because getting sideways, which we've had happen before many years ago, was really awkward and hard to get past.
I guess that was my and you answered it there, that there is a process that allows us to be out of neutral if it's done correctly. Yeah. Okay.
And John Sando, I think that we can certainly, especially with a new administration, it's probably very appropriate to invite, if there's a known natural resource policy advisor, to our February meeting, to schedule a meeting with the board, just like we would with the legislature, with the governor's team, potentially. That we can fit those in too, so that way then there's those connections being made early on in session as well, and so we can certainly add that into the either invite them to this formal part of the meeting, or as part of those legislative meetings also schedule a meeting with the governor's staff, and we can fit those in either way.
Miguel Lopez for the record. So Jonathan, so with that said, if it was, I'm just using this as an example, if legislation came up that affected one of us more directly than the others, should we kind of tap that person to be the one that we would want to be in charge of that conversation from the board?
So again, I think that if there's particular legislation, policy issues, those types of arenas that are sector specific, it's probably my recommendation and advice to stay within the sector and kind of keep it that focused. I think when we are talking about overall trends, kind of highlights, threats, opportunities to agriculture at large, that's when I think the board has that unified voice and kind of was able to carry that message forward in those areas. That's not to say that in those conversations you can't bring up wine vineyard specific things. Chad talks about dairy, but we're talking about it as more of an agricultural, ranching, fishing community as a whole. And if there are things that are more sector specific, those are probably conversations that are better had within those lanes.
Lauren Henderson again. The other thing that we have tried to do, and I don't know that we talked about this, Carla, for February, but to the extent schedules allowed, is to bring in the ag groups or our partners that we work with and have them tell you what they're tracking and the issues they've flagged. And if there's something that you think they've mixed, that's an opportunity for them to tell you what they're looking at and for you to provide that dialogue. That would be an appropriate topic or time frame for February if we could get the schedules. Brian, you've been part of those before, I think. Yeah.
And yes, we typically have at that February meeting invited industry groups to come in and share what legislative tracking that they're doing and issues that they're following. So that's typically something that we do put on the agenda.
Elin Miller, I think without belaboring this discussion, I think that the fact that if industry sectors are having issues, to kind of keep that separate, as you're saying, makes the most sense from my standpoint. But if it's some big ticket item, and even to suggest to the ag groups, if it's some big ticket item that impacts all of agriculture, the fact that there may be a process that we could as a board gather with Chad's idea to have a discussion and let the governor know how important it is, because it will be the governor's call. We serve under the pleasure of the department and the governor, but we are appointed to help in issues that relate to agriculture too. So it's that nexus. My past has been in other states where the Department of Ag served a very critical role in legislative policy with input from the board, and again through the governor's office, because we serve with the pleasure. So anyway, thank you for bringing it up, Chad.
I'm just interested on, because we know we had an issue that went through the legislation process last short session that impacted the industry as a whole. And so, how do we have that opportunity to properly engage and make sure that we do the job that we've been appointed to make sure that since whoever's in the governor's office is not going to be an expert in agriculture, but that's a role, whether it necessarily fits their agenda or not, I guess.
And it may give the Department of Ag an opportunity to weigh in where they may not have, because the board wishes you to weigh in for the conversation. I think it might help facilitate some of those discussions.
Yeah, Lauren Harrison, this is a good discussion to have. It's timely, so thank you for that, Chad. I mean, as I had said before, you all are here as not only a part of agriculture, but you represent all of agriculture, all of you. And that's a big job. We don't have room for 230 seats. And so you all have that. And so I think it's prudent that you are listening, particularly in your communities and what you're hearing, and that the process is there so that the executive branch doesn't give mixed signals, and it's organized in who's doing what and why. And then for the director's office, particularly Jonathan and I and our team, we will spend a lot of time opening doors and being available, particularly to new legislators. They don't have to do it, but just to say, look, if you have a constituent that brings something to you and you don't understand what they're talking about, call us. And then our job at that point in time is to have those one-on-one meetings just to talk about what we do and what that means for that particular issue. Those usually build trust, which is what we want, and transparency. And those kinds of conversations go a long way. And I did not use the word lobby in any of that because it isn't about that. It really is about what information do you need to make a decision or an informed decision, or even be able to sit at a hearing and have something about what we're talking about. That's going to be a challenge for us given the newness of a governor's office coming on board. There's a lot to do there, and then a lot of legislators. But we may be reaching out to some of you and say, hey, we got this. Do you have any idea what this is about? So we understand, and we're not going to be afraid to do that. So.
I don't know if there is another comment from the people joining, the members joining us remotely. If not, well, we will continue. I don't know, Carla, about the next meetings. Is there some discussion we need to follow?
Well, this is Carla. Remind people that our next meeting is in February, February 14 to 16 in Salem. We've identified a couple of agenda items that we, want to move towards getting on the agenda for February, the industry updates, and you've expressed the interest in having the one-on-one meetings with legislators, but I would like to solicit input for other agenda items that you'd like to see throughout the year. It may not be on the next agenda, but if you have a particular topic that you would like us to work towards getting on a future agenda, please email those to me. And I will also be reaching out to our internal executive team to see what ODA issues they'd like to bring forward to you as well. So I'm looking for input for future meetings. So that's my pitch for today.
Yeah, Lauren Henderson, I have one I'm just going to throw out there for a future, and maybe we'll time it out when we're at the coast next, which I cannot remember where it is. But I was fortunate enough when I went to London to be to go along with the Trawl Commission and things they did. They received basically a world award for certification from the Marine Stewardship Council based in London. That is a huge accomplishment. And I think it would be, we don't often hear from that part of what we do. I think it would be an interesting agenda item for the board at some point in time to have the Trawl Commission come, Yelena and some of her commission members, and talk about the work that industry did to become certified for sustainability as a fishery, to make sure that the stocks stay there when you need them. And that label is recognized in the world for that. So that's a topic that I don't think we've talked about enough, but it is a huge accomplishment. I'm really proud personally to have been part of that, but I'll just flag that for the group if that has some interest out there, because we don't often hear about our friends on the coast.
And then Jonathan Sando, a topic that came up yesterday on the OSU tour by some of the board members was a presentation from OSU's Bee Project, and having Andoni come and potentially talk about what they're doing and all that. Probably not for February. That meeting seems to be getting pretty full, but future meeting down the road.
Saying that, I think we're finished our meeting. Oh, yeah, yep. I know that lunch is coming, but I wanted to be sure that everybody had the opportunity to say something. All right, so I think we're ready for lunch. Early lunch looks like. And this is provided for the board members and ODA staff only. And keep your calendars ready for next meetings. And with this, the board meeting will reconvene. No, we will not convene until next February, I guess, right? And okay, I was training to do this. It's over. And thank you very much to have patience with me in this process of learning how to chair a meeting. All right, thank you.